Okay, I did have a bit of a bio, but I just had a great conversation with Anthony. And I just want you to have some context here that he's a very humble guy, but he is regarded as one of Canada's top IP lawyers. So we're absolutely ecstatic that he's here. We've had a great series of meetings today with some clients, and I learned a ton about intellectual property law and a handful of other things. So he's going to make IP very exciting. Hold on to your hats. It's going to be a fun, fun lecture. And without any further ado, I want to introduce Anthony de Fazekas. Thank you.
Thanks, Don. I feel slightly set up because making a general talk about IP exciting is a little bit of a tall order, but let's make it as exciting as we can, mainly by you asking any questions that come to mind. The presentation is a very long slide deck. We're not intended to go through all of it in 45 minutes, but I wanted to include a lot of information because some of you are actively involved in IP development. It's a great honor and privilege to be here because I have to say, Don and your ecosystem blew me away with all the technologies that you're working on. So it's obviously a very vibrant innovation space here, and that's why we do what we do. For us, technology innovation is one of our 6 headlights up there. Mining is there as well. So Sudbury is an important place in terms of innovation in this domain, and a big part of innovation is startups. So we love doing this kind of work. What are we going to cover? I want to just give you a bit of knowledge around intellectual property. What are the different forms? People get very confused about copyright versus patents versus trademark versus industrial designs. And so when you're trying to build a business in that domain, it's useful to have a bit of knowledge around that, just as a starting point. I'm going to cover some self-help resources because innovation is about helping yourself and getting organizations like NORCAT to help you help yourself. I'm going to give you some more tools. And then my favorite part of the talk is the IP strategy primer, but it also happens to be a part of the talk that you can get out of the slides, I think, because I designed the slides to really give you the information that you need. So we're not necessarily going to cover it in too much detail, but I know that the slides are going to be available through NORCAT, so you can email Don or somebody else at the office. And then hopefully, I'm hoping there's going to be questions, examples, and just interrupt me at any point in time. So we're going to cover the main areas of intellectual property, which are patents, trademarks, industrial designs, copyrights. There's other forms of IP. We're not going to get into too much detail, but good to know that they exist. Plant breeders' rights, integrated circuit topographies, and of course trade secrets. We will talk about trade secrets a little bit. And it's important especially to understand the interplay between these different forms of intellectual property, and so that's what we'll talk about. So what is a patent? Obviously it's an exclusive right. It's mainly a right to restrict other people from doing something, from practicing an invention. It's very much dependent on the numbered paragraphs in this document called the patent. Whatever is embodied, described in those numbered paragraphs, that's what you have exclusive rights to. Unfortunately, it's not a self-enforcing domain or mechanism. You actually have to enforce your patents. Although, as we were talking about in some of our meetings earlier today, my experience has been, and I live this at BlackBerry, people don't really ignore patents anymore. Even large companies, when they come to, let's say, us and say, oh, there's a startup, they have a pending application, the advice is not, don't worry, ignore it. After all, Research in Motion now, BlackBerry paid $625 million as a settlement to NTP. And so really, a lot of the industry changed after that, frankly. And so the advice would be, this is what we think the startup can get out of the patent. Maybe they don't have the money to enforce the patent, but maybe your competitor will fund their litigation. It was rumored at the time with BlackBerry that Nokia was funding the litigation. So patents are these interesting fluid rights that have lots of ways in catching up to you, even if you're a very large company with very deep pockets. So ownership in terms of who owns the patent, I mean, this is a really important aspect because it's a natural right that arises from production. So whoever conceives and reduces to practice the invention, they're going to own the patent. So these loose collaborative founding groups where you don't have necessarily agreements as to who owns the IP can be a little bit problematic because then you end up in a joint ownership situation. And the patent is going to allow you to have a 20-year term, and it's very much based on a bargain. So the state, let's say in Canada, is going to give you this patent, but in exchange, you have to disclose the invention because the patent application is going to be published after 18 months, And after the patent term is over, after 20 years, then everybody gets to use that knowledge. It's in the public domain. The flip side of that is that you really do have to give quite a bit of information in the patent. So you can't just be extremely high level about it. So one of the immediate interplays with other forms of IP is, I have certain things I want to protect as a trade secret, but I want a strong patent. And sometimes to get a strong patent, you give away a bit more than you would be comfortable giving away. And finding that right middle ground can be a little bit challenging, but with the right advice, it can be done. So what are the main parts of a patent application? I mean, first there's this abstract, and and then there's a title, and then there's the field, as we call it, the background, which is sort of almost like a pain statement, if you're used to doing that in a business plan. What are the old solutions? What are the problems with them? What's the market opportunity? It's very similar to that. And then we have something that we call a summary of invention, although there's recent case law, we don't actually call it that anymore. We just call it a summary because there's negative implications sometimes. And that basically restates the claims. And then there's a brief description of drawings explaining these are the drawings, figure 1, 2, 3, 4, 5, 6. This is kind of what they show. And of course, we have a full description, which really tells the story of the patent. Usually you start high level, get into more and more detail, stopping short of those trade secrets, basically, or whatever you think you shouldn't get into. And then eventually you have the claims, and the claims are highly technical. So really the description is very similar to a technical disclosure, but rewritten. But the claims, in terms of the words that are in there and the words that aren't there, it may be 2, 3 pages long, but it takes a long time to write them properly. Because of course, all of these patents are written with the expectation that we never know which patent is going to be resulting in a large lawsuit. And so we worry about how is the judge going to interpret those claims. And even if it doesn't become a lawsuit, if somebody's looking at the value of the patent, they're going to be hiring somebody else to poke holes in it. So from a valuation perspective, from a strength perspective, a lot of times, the difference between an investment and no investment, or an investment in a 2x or bigger investment, is the quality of those claims. So we take them very seriously. And then sometimes we have, in biological areas, we have these other things you have to provide along with the patent application, like a sequence listing or a deposit of actual biological materials, which is kind of gross, but, but that's what happens. So an example of a patent that everybody can relate to, I like sandwiches myself, so this is why I picked this. And I also find it very annoying that sometimes what you want to put in the sandwich, it goes beyond the borders of the bread. And so this is a pretty basic idea. However, it actually turned into a pretty good patent and a pretty good product. I saw it somewhere in Europe when I was traveling, and I thought, oh, okay, that's a pretty cool idea. So I found the patents for them. And so it just illustrates that the front page, which you usually will see, and we're going to talk about the self-help stuff in a minute, this is kind of the first page that you will see to give you a sense of what is this about. It's always very drawing focused because a picture always tells 1,000 words. So the first page will have a bunch of gobbledygook on it, which I will explain, but the main thing is that there's this drawing which does immediately, along with the title, give you an idea of what the invention's about. And that's the whole idea, because it helps you screen through these patents pretty quickly. In terms of, here you see the applicant, it's McDonald's. This is a McDonald's patent. And you can see the inventors and the address, their home residence has to be provided, who prosecuted this patent for them, what firm. And then these designated states are there because this is a PCT application, which means Patent Cooperation Treaty. So this is an international application. And here you can see all the countries that were designated at the time. So usually we, pretty automatically, we just decide to pick all the countries. Of course, in case we decide we want to patent in those countries, and I'll show you the timeline of how this Patent Cooperation Treaty works in a minute. And not only was it filed obviously internationally, but there was a published US application, so after 18 months, essentially the same subject matter, slightly different formal requirements, the same technology was covered in the US. Important thing to remember is that a patent application is nothing other than a wish list. It's what the applicant wants to patent. It doesn't mean that they're claims are going to be approved. So a lot of times people say, oh no, there's a patent covering what we want to do. And we say, oh no, it's just an application. We don't think they're going to get those claims. They're too broad, there's relevant art. So what happens is that eventually these patent applications get reviewed in different ways. Internationally, the way it works is actually within 5 to 6 months, you will get an international reviewer comment on the claims and do a search, which we like the predictability of that. In the US, who knows what's going to happen, especially with the budgetary issues and so on. It slows down, it speeds up. So it can be a little bit difficult to know when things are going to happen for you. There is, however, an excellent online system in the US called the PAIR system, P-A-I-R. You go to the USPTO website, you find out, let's say, this application number that's right here, 11// you put that in there and you can see everything that the examiner sees, every single document that was filed, the back and forth. You can see how that examination is going, what other patents are being cited. Is McDonald's going to get a broad patent or a narrow patent? You can see all of that, and you can do that by yourself. Self-help, save a lot of money. And of course, eventually people will sometimes get around to filing in Canada. Not as important a jurisdiction, perhaps, from a market perspective. Most of the work that we do is actually for Canadian companies, but filing in the US and internationally. But we do file in Canada as well, obviously. And so you can see they did the same thing here, same idea. Now here is an example of a claim. So we talked about these claims and how important these claims are. So you have an understanding of what it looks like, roughly what the invention is. How does the claim actually read? Well, it's a sandwich assembly tool for making a sandwich composed of at least a bread component and a sandwich garnish. That makes sense, right? So far, right? Sometimes these claims, you read them and you don't know what they're talking about. That shouldn't be the case. It should be pretty clear. A member comprising two separate, I would not use that word, but in any case, this is where you can start seeing, well, there's a bit of strange terminology that's creeping in here, and roughly it's because you don't want it to be read as a plate when somebody could design around it and have a different word. So sometimes we use these really generic words. We might as well have said a thingy comprising two separate spaced apart cavities for holding sandwich garnish material to be applied to a bread component for a sandwich, each cavity having an opening located in substantially the same plane. That makes sense, at least to me. Maybe that's a bad sign. Anyways, a quantity of sandwich garnish material contained and in contact with at least one of the cavities. So I mean roughly just trying to keep two areas apart. One garnish area, another garnish area. So there's different ways of claiming things, but in any case, this gives you a bit of an idea of how it all works out. Now, what is actually patentable? It has to be a new technology. So in the case of McDonald's, I don't know how many other sandwich garnish separators there were out there, but any other sandwich garnish separator that existed just because somebody made it and used it to make sandwiches on a street in Bangalore, or there was actually something being used by Subway, all of that is prior art. Anything that's out there in the public, either described in a document or existing as a product, that attacks the newness or novelty. So you have to show that as of the date of your patent, whatever that relevant date was, there's nothing out there in the public domain. Or sometimes what's often the case is your technology is a bit of an improvement. So let's say, in fact, that there was another sandwich garnish separator, but there was some improvement that McDonald's had come up with, which I can't really think of one, but maybe this claim shouldn't be allowed. And it has to do with the capacity and understanding what the right type of volume is that should exist on each side. Possibly it's that narrow. What's that?
Bread to garnish ratios.
Bread to garnish ratios. Maybe that is some amazing insight that McDonald's had and their engineers developed for several years. Who knows? And then it has to be useful. That's pretty easy to meet that threshold. It has to be patentable subject matter. Certain things still are not patentable, like abstract theorems and algorithms. Sometimes the method that's embodied in them, or an internet platform that incorporates an algorithm that executes a series of steps, that could also be patentable. But you can't patent math or the laws of nature, right? And more importantly, the technology has to be non-obvious, and that's really the tougher hurdle for people to meet. So the idea of non-obviousness is that you may not find the same sandwich separator, but there may be a similar one, and the argument is it would be obvious to somebody who develops these sandwich separators to make whatever the change was, such as the sandwich, the bread to garnish ratio. And if that's the case, that's where the battle happens, because eventually these patents are going to be examined by a patent examiner, say in the US, and we run into some real tough arguments with them sometimes. We are, I think, very good at getting broad patents through if they're deserved. But sometimes the examiners do crazy things. Like, first of all, they don't understand the invention, they don't bother to understand the invention, and then we have this one case going on that everybody's really angry about at the office right now, where they've combined 5, not 1, 2, 3, 4, but 5 really unrelated references, and really mosaicing, saying your claim, I can find it in all these places. And so you have to sort of construct these arguments to say, it wouldn't be obvious to combine A and B, and A doesn't suggest going to B. And in any case, somebody skilled in the art in A is not going to know anything about subject matter of B. So these are the arguments, unfortunately, you have to make. And eventually we tend to succeed, but it's a very frustrating experience for us, and even more so for the paying clients, right? So that's what it is. Certainly there's things you could do to push things along. We have all kinds of strategies, like the interviews. We subscribe to all these data that tell us the average case based on 1,000 sample size in the USPTO. How does it fare? How many rejections are there? We have all kinds of interesting strategies. Like the latest that's come through is that if we get a perfect review at the international level, because of the budgetary cutbacks, we're getting notices of allowance in the US immediately, which is like winning the lottery. So there's a whole bunch of strategies that we're doing around that, but it's very much based on what you heard, and in a big firm we all share information and tips, and we actually have a collaboration site where we post this stuff, so it's pretty involved because these are important assets. So of course you don't want to reinvent the wheel, right? You don't want to do that in business, and you don't want to do that in patents either. So I'm a big believer in searches. Searches, however, they take a long time and they're expensive. But we invested a lot of time, more test scenarios, and we actually found, finally, despite much skepticism, we found a really good search house in India that does a search for $800 to $900 that we're happy with. And that's kind of the right price point, because if you're trying to build a startup business and it's maybe $5,000 or $6,000 to do a patent application, but somebody tells you it's $3,000 to do a search, something's off with that math. And so we're pretty happy with that. So far it's been pretty good. And you really want to understand where to focus. Like, even if you're pretty sure that you have something that's patentable and it's a great idea, you want the patent, of course, to provide more details and concentrate on the aspects that are innovative, as opposed to the ones that are pretty much mapping to somebody else's patent, right? So you want to really understand what the context is of your invention. That's what the search provides you. Of course, you want to get an idea of what competition is too, so that's related to that. Now, there is some big changes. Some of you are probably aware of this. In the US, it used to be a first to invent system, which meant that you could file a patent before me, but if I showed that I invented it first, I get to knock you out. Well, that doesn't work that way anymore. So it's much more of a race to the patent office. So when those changes came into effect, which was March 2013 basically, there was such a rush to the patent office, it was ridiculous. Like, people were filing patent applications, left, right, and center, didn't even develop the technology yet, so it really changed the outlook of the US on patents, and they're of course a heavy filer. But you have to be careful, because at the end of the day, the way this works, and we'll see it in the timeline, is that you file a patent application, but it doesn't really talk about what the invention is, and then you go and disclose that invention, and then you file a patent application afterwards, and you want to backdate it so that you basically filed ahead of your disclosure. If it's not a very good document and doesn't really explain what the invention is about, then it's probably not going to have that effect, which means that you've disclosed the invention, and unfortunately it's not patentable anymore outside of the US and Canada, for example. So there's some serious implications. You have to be careful. So and here are the disclosure rules. So in US and Canada, we have really, we're pretty lucky because we have this idea of the grace period that we can still patent in Canada and US. We can, even though there's been public disclosure. So for example, in Japan or Europe, you must file a patent application somewhere prior to your public disclosure. In Canada and US, you can just try out the technology, see if you're going to make money, do all those kinds of things, and still file within a year. People often mistake, however, they think they can file within a year in the US and then get around to filing in Canada at some point. It doesn't work that way. You have to file in Canada within a year of the disclosure. But what kind of disclosures are we talking about? We're talking about public disclosures, right? And so the issue there is that first you have to think about what your invention is, and then you have to think about whether or not there's been public disclosure of that invention. So sometimes people disclose something, but it's very high level, but they don't really give away what the technology is actually about. It might be some kind of technology in the back end or black box. If that's the case, you're okay. But this is the problem. A lot of people, they're not sure what aspect of their technology is patentable. So it's very important to get at least high-level advice on that. Otherwise, it's very difficult to navigate the system. But confidential disclosures, for example, it came up actually one of our meetings today. One of the companies, it was the kind of technology where to try it out, it has to be out in the public. So some of the best cases on public disclosure in Canada have to do with that kind of scenario. My favorite example is there was this man who came up with this great new fire poker, and there was a patent on it, but he had a party at his house, and he tried to sue somebody based on the company was using the same design. Problem was, what came out in the evidence was that he had this party, it was out on display, yes, he invited the folks, but it wasn't really a confidential setting. He showed the poker and was very proud of it, blah, blah, blah. All this came out, and so that was a public disclosure. So his patent was invalid. So we do have to be very careful about these things. How are we on time? Okay. So in any case, but if you're disclosing under confidentiality agreements, that's also okay. Or even if the setting is confidential. So for example, if you meet with investors and you mark the information confidential, or that's the understanding, or you say, this is confidential, that should be okay. What is not confidential is, for example, pitches that people do in public settings. That's the classic, right? Like there's demo days. That is not confidential disclosure at all. It doesn't matter if it's you know who the invitees are beforehand. It's really hard to meet those rules, and those are typically the scenarios that result in the classic "oops, gave it away." And the classic scenario is the company thinks that what they have is not patentable in a broad way, and it's only afterwards that we meet them and realize, oh wow, this is very interesting technology. Nobody at a high level has this kind of internet platform or something like that. And the problem is that high level disclosure was given away, so their broadest claims have now been disclosed. You can get narrower claims, but then now those are easier to design around. So it's kind of too bad sometimes. Yeah, I mean, whether to file and how to file, I mean, there are lots of factors. From the meetings today, we had some interesting discussions around this, but I mean, roughly the way I would look at this is that to initially get some advice through organizations like NORCAT, you can get some initial advice. To get investors on board to an idea, you probably have to protect yourself a little bit, so you have to get something started, maybe a US provisional patent application. That doesn't cost that much money, and sometimes you can even do it on your own, and that's not as good as getting somebody else to do it. It won't be as strong, but it's still better than doing nothing. And then we'll see on the timeline that within a year, what happens is then you have to formalize the application, spend some more money. So far, it's all manageable, but then prosecution gets very, very expensive. So in sort of a simplistic way, the way I like to look at it, is that you have a year to really, really get going on this and see if there's going to be serious money or not coming out of the technology. So here's that all-important timeline. So this is what gets people extremely confused. So this is where we file, let's say, our provisional application in the US, and then we have a year within which to complete right? So that's a 12 months. So that could be the PCT filing. So let's say, sometimes what we do is you try to file a US provisional prior to disclosure anywhere to maintain your ability, say, to patent in Europe or Japan. So we file a US provisional right here. And then we have a year within which to either go national right away or to file the PCT application. The reason why I want to file the PCT application is because we're not sure what country we want to go to. And translation, going to a lot of countries can be extremely expensive. So you want more time to find a licensee, raise a whole bunch of money to pay some of this stuff, test the market. One of my favorite examples is I had a client that reached this stage, which is where you have to decide what countries they go to. And normally companies go back and forth. They really struggle with, they want to protect their market, they want to go broad, but they're not making a lot of money yet. And so this technology had to do with nanotechnology that improved, essentially fertility treatments. But it was a really good technology. And, they came like around here and said, we want Netherlands, Sweden, US, Canada, and that's it. And I said, wow, that's very specific. And they said, well, that represents 78% of our realizable market because A, they have a problem with these issues, they have the money to spend on it, the healthcare covers it or whatever. Well, 78% of the realizable market with a relatively narrow list of countries is absolutely fantastic. And that's kind of what you're trying to accomplish, cover mainly your markets. So at 18 months it publishes. So that's when everybody knows about your application. At 30 months, then that's where you're really struggling because you have to decide where you're going to go. And what I tell people all the time is a lot of very large companies have been, their IP was just in the US, and maybe they added Canada, and yet they had big, $100 million valuations. So people get a little bit stressed out about all these countries where you end up having no traction, right? So China is actually a pretty inexpensive country and a big market and great patent system. Everybody thinks that it's China, so there's no intellectual property enforcement. You cannot probably enforce a trademark very effectively, but in the inimitable Chinese way, they've gone from being very backward in their patent system to the most modern. Like the best prosecution we have right now, there's Facebook and Yahoo are bidding on this portfolio right now that we're dealing with, and everybody's most interested in the Chinese prosecution because it's a big market, they're further ahead, they know what they're doing, it's very interesting. And so, there are countries that are big and not too expensive, and there are ones like, South Korea, early adopter in some cases, but small country and really expensive to get a patent. Brazil, great mobile market, but also very expensive. So, it's very important to understand that sometimes the mistakes or just things that happen, not because of anybody's fault, but some of the things that are involved in drafting the patent application then are going to kind of hit you afterwards. So just because you have a patent doesn't mean that it's necessarily valid. We have a huge pharmaceutical litigation practice in our office, and it's all about defending these patents against the generics who will bring up every single thing. And so there's ways to attack patents that you have to realize. I wanted to use an example of a actual client. Not giving confidential information away, it's all public domain. But I thought they would be an interesting example because it shows the interplay between all these forms of IP, and also because I think it's a technology that's probably interesting in Sudbury because it's an amazing mining technology. So Vital Alert is based in Ottawa, and basically they provide underground communications in mines, which is a big, big issue, wireless communication. And so we built some patents on their base technology. It came out of Los Alamos Research Institute in the US, and then we built on it and improved it. And then we figured out that there were other applications, including detonation, which is a huge issue. So we built separate patents around that to extend the reach. So their product is in underground communication. They're licensing Raytheon in the safe detonation area. And their trademark is Canary. So I'm not sure that that's necessarily, it's cute, but I don't know. In any case, it seems to be working for them. So it's pretty common to have a name of a company and then a different brand for your product. And then, we were pretty concerned, is Canary registrable? Because you don't want to invest all these marketing dollars in a brand and then it turns out that you can't use it anymore. Somebody can send you a nasty letter and you probably should stop. Want to avoid that. We actually, there were possible registered circuit topographies because it's a very electronics heavy technology. We didn't end up filing because we didn't think it was worth it, but we could have. The other thing is that we have some really interesting things that we can do with industrial designs. For example, probably lots of iPhone users in here, I'm assuming. So the landing page, the home page of your iPhone, just where you see the icons and the columns, that's a registered industrial design. So we were acting for Samsung in that litigation, and that was not fun because it turned out that was a highly enforceable design, even though it seems pretty generic. Apple was the first to come up with that kind of interface. So industrial designs are the shape of a chair, but UI is kind of ornamentation shape applied to a two-dimensional screen on a display, a computer display. So it's same kind of protection. So when we're dealing with software companies, we're always looking at not just at their functionality, but their UI and their UX, because you can get some really interesting protection around it. And then what's even more interesting is, and we actually are doing this with Vital Alert, is that their unit's sort of like a backpack, but it's really got a cool shape to it. It's very recognizable, and so we're registering that as a trademark. So for example, the Perrier bottle and its very distinctive shape and outline is not only an industrial design, it used to be an industrial design, now it's a trademark, and trademarks are renewable forever. So industrial designs have a term, but distinguishing guises can be registered. The other distinguishing guise that I did, which I think was pretty creative, was the UNICEF box. I registered a trademark on its shape, like very generically, the rectangle and the slot at the top, because there are a lot of charities, especially in Quebec, that were creating boxes that looked the same, and parents were throwing money in thinking it was UNICEF, and it wasn't. And so the idea is that create your own box that's not confusing. We're not trying to say that any box is off limits, but if it looks like the UNICEF box, don't use it. And so we made them all stop. Yes. Copyright protects computer code, marketing materials in relation to Vital Alert. And what's neat about copyright, it just exists. Like you create stuff, it exists. You can register it, but you don't really need to. Sometimes you register it because you're going to sue somebody. It takes a couple months to register it. So it's this great protection that kind of just exists there. Trade secrets are very important. So for Vital Alert, they've got some interesting algorithms. We certainly did not include it in any of their patent applications, nor will we. But trade secrets are important because if somebody leaves the company, or if we disclose certain code to Raytheon, as in fact we have, if they use it in an appropriate way, we will come after them. But if we can't show that we treated that code with the respect it deserves, or in a way that is really contrary to it being a trade secret, then we're not going to be able to sue them. So we have to make sure that we don't leave stuff lying around. We have procedures in place where the source code is encrypted. There's field level encryption in the database where it resides. Only certain people have access to it. There aren't any hard and fast rules, but you have to have that kind of set of policies, because if you ever need to go to court to try to get an injunction to shut somebody down around some of this stuff, then you better be able to show the judge that you have these kinds of policies in place. And these are basic things that every small company can do, right? So it's not difficult. So here are some just like self-help tools. The site is always changing. But the USPTO website, you can get so much information there. You can do class-based searching. Usually the way you search is, well, the way I search, you start at Google Patents, kind of get a rough idea of where you are. And then you go to the USPTO website, and every single patent and patent application is classified. So for example, if it's a crowdsourced management platform, internet platform, there's a class subclass for that. So once you figure out some relevant patents in the domain, you look at those class subclasses on the front page. Then you go to this area, kind of read these 30-page documents that really explain how all the information is organized based on the rules that USPTO has. And then eventually you'll figure out class, subclass combinations that relate to your technology, maybe 2 or 3 of those. And then you'll narrow automatically that search down to, let's say, 300 patents, tops. And then you can filter those through, and that's a very good search, right? And you can do that on your own. And that way, no matter what crazy words are used, because we patent agents are very good at using synonyms, and we all have our wording that we think is so, such an apt distillation of the technology, but it can get pretty goofy sometimes. And so you really cut through all of that, because regardless of the words used, somebody's read that patent and classified into the system. And this is the pair system I was talking about. So you can see all the back and forth, the examiner. Same thing in Europe. There's some good tools. Canada, not so good. you can't access the file wrappers online. It's so embarrassing. Especially considering that the technology used by the USPTO actually was developed by CGI, in any case. And then there's a bunch of slides on IP strategy, which you'll probably find interesting, but I don't think we need to go into them today, but you can get access to them. And they're pretty self-explanatory. You can, but it has to be the kind of invention where it can't be understood through drawings. And that's very rarely the case. So that's why there's an exception for biological materials and things of that nature. Sometimes there are certain very complicated prototypes that it's just very difficult to actually take apart or show in cross sections or whatever. But that's very, very rarely the case. So usually if you try to submit the article with the patent application, it'll be rejected. And then if they reject it and you don't have the drawings, then the question is, do you lose your date, your filing date? And probably yes. So I wouldn't try that. Yeah, that's a really good question. So a provisional patent application, what's neat about it is there are very few rules. Usually we always include at least one claim, because to have a priority basis in, say, Europe, it has to be a real patent application. And from a European perspective, it's not a real patent application if it doesn't have at least one claim. However, beyond that, there are lots of things that you must meet for the non-provisional applications, such as drawings, requirements you don't have to meet for the provisional. So provisional, you can submit colored drawings, screenshots, like just a whole bunch of stuff. What matters is the substance, not the formalities. Now, if you want a strong priority date, however, here's the problem. Usually when you're trying to get a claim through and you want to make sure that claim, that language tracks through to the provisional, if you just kind of pull together a technical disclosure or white paper and it doesn't use some of the same words, you may run into a problem of the priority of that claim. So basically, the rule of thumb is just trying to make sure that provisional is as complete as possible, but you don't have to fuss about the drawings. And so that's why it's less expensive and easier to pull together. Right. So in a way, the provisional application is never really reviewed. That much is true. However, whenever you enforce your patent, the first thing they're going to do is look at the claims and see if there's a proper priority basis. So they will look at it from that perspective. The other thing that's important is that when you rely on that provisional application for priority in other countries, through the PCT process, you have to provide your provisional application, and they actually do. The more diligent examiners will look at it, right? And they may deny your priority claim if they don't find the subject matter disclosed. It's actually happening more and more. Yes, the answer is definitely yes. So usually to cover your, well, first of all, investors won't sign NDAs, right? That's just like, and everybody, like, good luck saying, well, wait a minute, my lawyer said you have to sign an NDA. They just don't, and people do need money. And so for that reason, you have to kind of file some IP. And also, and I run into this all the time. It came out in one of our meetings. Unfortunately, there are companies out there that sign NDAs, take information and steal it and even file patents around it, and it happens all the time. In fact, there's some companies I will not mention, but they have a floor of patent agents that are just taking literally disclosures and filing applications around it. And then what happens, they may not file on your disclosure, but for example, you may come to me with your idea And then I realized, well, wait a minute, to take that to market, I have some ideas around the applications of your base technology. And then when you come to me and say, let's do a license, I'll say to you, well, that's very nice, but actually, you can't go to market without my IP. So we're not going to pay you half the royalty that we discussed. And in fact, you owe us a royalty, so we have to do a cross-license. So really, we owe you nothing, or something along those lines. And so that's partially why you have to file proper patents. Non-disclosure agreements are not always worth the paper that they're written on, because you have to prove that somebody took that information and that their product was actually based on your disclosure. It's very easy for the large company to say, well, actually, on the 7th floor, there was this group that we didn't know about when we met, and they were working on the same technology. And if I say that, what are you going to do? Are you going to, are you going to spend $1 million trying to sue me? I don't think so. So in any case, that's why non-disclosure agreements, they're okay, but you have to really look at who you're dealing with and whether you trust them or not. And so I think one of the important things is really selective disclosure. Well, not so long as the disclosure is fully covered by your IP, but that's the issue because the technology is constantly evolving, and you have to make sure that your IP is ahead of your disclosures in relation to your technology. So the problem sometimes is that people file, let's say, a provisional application, but then they haven't updated it. That's why I sort of force clients on a quarterly or a monthly basis to say, okay, have you changed something? Because sometimes you just add a page and a drawing to the patent application, but guess what? That could be the critical market differentiating feature. And also, fast forward several years into patent prosecution, that particular concept may be what gives you the broad claim that is really meaningful to you. Well, if you disclose that further aspect, and it wasn't part of the provisional application, then technically you don't have that same priority date. So there's a real onus to update these things. What's neat about the provisionals is that it's only $100 to file. A non-provisional is $1,400 to file. So you can add some more information, add another drawing, and just throw it back in. So a lot of our clients, they're sort of doing these follow-on provisionals almost on a quarterly basis. And that way you can stay ahead of the game. And then on top of that, you try to have your non-disclosure agreement. And what's more important is sometimes people, I find, they aren't limiting their disclosure to what they really need to say to advance the goals of the meeting. So I think people need to ask themselves, what are you trying to get out of this meeting? Are you just trying to give them a taste for the technology? Who are you disclosing to? Do you need to get into a real technical disclosure yet or not? And usually the answer is, you don't want to disclose everything. Why would you? You're trying to show them, what is the technology generally? You're trying to show them validation. You're trying to show them results. How you actually produce those results is probably none of their business, at least not initially. Yeah, that's kind of part of it. I mean, it very much depends on the technology, to be perfectly honest. So, I mean, certainly if you want to have the priority date, the provisional application at least has to provide enough suggestion to somebody skilled in the art to actually practice the technology. Otherwise, you don't really have a valid priority date to that claim. That being said, you don't have to have all of the detail necessarily laid out, yet it makes your patent stronger once you have that detail to include it. Partially because you want to have some broad claims and maybe some narrower claims, partially because the broad claims may end up being invalid, whereas the narrower claims may still cover your competition, but they're more likely to be stronger and valid, right? So just to clarify, I mean, 18 months is the publication, but you have to file that non-provisional application within a year, just to be clear. So it's provisional, non-provisional, and then it's the non-provisional that publishes at the 18-month point. All right, so anyways, one of my, I don't know, maybe they're not even in these slides, but, but the key issue is non-disclosure agreements. I see really, really bad non-disclosure agreements all the time. They come from various sources. There are two very important things that should be in a non-disclosure agreement. I'll explain why. Number one is feedback clauses. Okay, so oftentimes you have a non-disclosure agreement, But you're getting together with somebody that actually may have ideas about your technology, and they may provide you those ideas. So I have this really, really bad story to tell you. So this client that came, they filed a patent on their own, and then they came to us. And they already had a licensee and distributor lined up. It was a very interesting technology, actually. And then we filed a PCT application covering some improvements. And then later on, we got involved in the licensing, and then we saw that they had a non-disclosure agreement with no feedback clause. I thought, ooh, gosh, I hope everything's going to be okay. Well, it wasn't okay. The company looked at the PCT application, said, we think that some of these changes, even though they're completely natural, came from us. Like, we introduced these ideas, and so we're not going to pay you that royalty anymore. In fact, we want you to withdraw this application, just a bunch of mumbo jumbo. But all of that could have been avoided by having a feedback clause. So a lot of the ideas of disclosure is to collaborate, and collaboration seems like a great thing. But unfortunately, people are sometimes playing sort of bad tactics with you. And so really what they're doing is they want to trap you with this feedback. And you know, in our case, actually, there were really terrible arguments because anything that they came forward with, the suggestions were obvious to anybody. But now we're in the situation where, you know, our client wants to avoid litigation, and so they're lowering their royalty. They're actually probably willing to just offer it to them for free to avoid litigation. So you have to make sure in your non-disclosure agreements there's a feedback clause. And feedback clause is very basic. It basically says, if you give me ideas about my technology, I get to use them. I get to make improvements based on your ideas, and I own the IP in my improvements. And a non-disclosure agreement that doesn't have that clause, I think is problematic. Now, it may be that they don't accept it, but then you have to delimit the discussion. You have to make sure that you don't want to get their feedback. You know, like to the point where if there isn't a feedback clause and you start saying, well, couldn't you have this feature to the technology, or could you use your technology this way, so meeting's over, or something like that. Literally, that's how dramatic you have to be, I think, in these situations. And then the other one that I like introducing but never expect anybody to sign is, it's called a residual knowledge clause. And what that means is, not only can you not use the information or materials that I give you, but if you think about what I'm saying to you and then you learn something on your own and it's in your brain, you can't use that either. And, and it seems very a hard to enforce clause, which it is. And nobody in their right mind would accept it, although at BlackBerry we had these clauses all the time and people did accept them, and it was very useful actually. But the thing is that when they say, I don't want that clause, then I say, well, why? Then usually the answer is, oh, well, we're kind of working on something somewhat related. And you're like, oh, I didn't know that. So maybe we should rethink how we're going to work together and what you access and what you don't access, and what selective disclosure means in the circumstances. Yeah, there's the tremendous arrogance or laziness to trade secret protection, or both, in my opinion. Because I mean, it's not so much just the that aspect, but independent creation will always be a defense to trade secret protection. So if I come up with essentially your algorithm or something like that on my own, there's nothing you can do about it. You would have to prove that, you know, there's a breach of a confidentiality provision, or one of your employees came over to mine and that's how I got access to the information. So by saying that trade secrets are going to be adequate for you, generally what you're saying is that even though there are big companies out there trying to do the same thing as you, they're never going to be able to come up with it. So there are very few areas that where trade secrets truly work. Where trade secrets do work, I think, is usually in combination with patents. That's usually the way it works. So for example, the patents would cover the broader aspects, and then some of the implementation aspects that might be changing, that will be covered by trade secrets, in part because you don't want to teach too much necessarily to your competition. So the classic might be Locationary, for example, that was bought by Apple. We filed all these patents on crowdsourced management using gamification, but we didn't necessarily say in the patent what the specific gamification techniques were, or what the directory or the map data scoring mechanisms were. That we kept away. So it was like a combination of the two. But sometimes what happens is the company is not sure what to do about patents, and so they just say it's all trade secrets. And And unfortunately, the problem is that patents, even without enforcement, do have a chilling effect. And so you're not really slowing down your competition with trade secrets. They know full well they can do the same thing on their own. I mean, sometimes it happens. It could have been through that route that I was talking about where you file a PCT application first and then you get a notice of allowance. We had a client where it just, I don't know, just weird stuff sometimes happens. We filed a patent and we had a notice of allowance in 2 months. Sometimes what happens is that, and they're not really supposed to be doing this technically, but there's a new rule that says every application must be prosecuted. I'm assuming this is in the US, right? Yeah, so there's a rule that every application must be prosecuted or examined in sequence. But what happens is that the examiners are rewarded based on a point system. So, and they get bonuses based on their activities. So you get a certain number of points for an office action, a certain number of points for an allowance, a certain number of points for forcing a request for continued examination. So there's this whole point system. And then oftentimes we file applications that are connected to one another. So some of you may have seen that you read these patents that all sound the same. It's the same description, but the claims are slightly different. So those are continuations or continuations in part. And so what happens is the examiner is already, let's say, allowed a case. If you let them know that there is a related case, then they're probably going to pull it out of the normal process and look at it because they've already know the description, so they can get their points with very little additional work. So that could be part of it. There are those fast track mechanisms which almost guarantee an allowance within a year, but the problem is that it may be very narrow. So there could be different explanations to that, but that's not the normal. Like we have the data on what the normal allowance from filing. It's now the average. It depends on the art area too. So in mobile, it's actually a little bit faster. So in mobile, it's roughly, the average is 22 months to allowance, which is actually faster than data processing where it's 37 or something like that. So it depends. So patent pending just means that it's not allowed yet, right? It's not a granted patent, it's an application. And if you can see it, it means that it's published. But it doesn't mean that they're going to proceed with it. It doesn't mean that anything's going to be allowed. No, I mean, usually what happens is that if it's important enough, you're going to get advice from somebody as to what are the probable outcomes out of this patent application. So we do our own search, we look at the quality of the description, and usually, to be honest, we take a pretty fair and objective approach, I think. Like there's no point being overly critical because, in fact, generally speaking, if people invest the resources and they have good counsel, they're going to get patents through. So we don't want to advise a client that there's no chance that there's going to be a patent here because that can, we don't provide that kind of advice very lightly. So that's what happens typically. So, because technology works, moves very quickly and the patent system is slower, the reality is that, yeah, patent grants are important, but a lot of these deals are happening based on pending applications, right? So look at the locationary deal. We didn't even know we were dealing with Apple for the longest time. It was some, who knows who the buyer was, very confidential for a very long time. But there wasn't a single granted patent, but they did a lot of homework and they looked at it, they looked at similar patents, they ordered these patent maps, we commented on patent maps, and then they quickly realized that the foundational, the earliest IP talking about management of a crowd through an internet platform to create data and aggregate data, that we had the best and, well, the earliest and the strongest IP. And there wasn't a single granted patent. That we didn't even receive an office action, and yet the valuation on the patents was enormous, enormous.